Good evening, gentlemen. I'm sure our day was quite healthy. You're welcome to tonight's online session. I still remain your host, O.O. Stevens, and we are going to be looking at the topic election petition in civil litigation. Election petition in civil litigation, and our interest in this particular topic is to see how a person who is aggrieved or who was aggrieved by the conduct of an election would have to go about it. The one thing about election petition before we start is that it is sui generis, meaning that it has the life of its own. It has its own principles, it has its own rules, it has its own regulations. So, and the regulation of election petition is made by the Electoral Act. It is made by the Electoral Act. And before any election can be conducted in Nigeria, there must be an Electoral Act in place, because it is that Electoral Act that is going to specify the processes or the protocols to be observed by the electoral umpire. And for Nigeria, we call them Independent National Electoral Commission, INEC. Now, election petition now is the process meant to challenge the validity of an election. This process is a special procedure on its own. That is why I told you that it is sui generis. Sui generis is S-U-I, you shift, you write G-E-N-E-R-I-S, that is sui generis. Now, all actions arising from the conduct of an election are commenced by way of petition. If you remember the mode of instituting or the mode of commencing a matter in the High Court that we treated earlier, remember we said that we have petition, and petition is used when it is with respect to election matters, matrimonial causes, winding up of companies. So we are repeating that same thing now. An election tribunal shall be constituted not later than 14 days before the day of the election, and its registries must be open for business 7 days before the election. Now, an election petition must be filed within 21 days after the declaration of the result. Please follow me. It is within 21 days after the result has been declared, not after the election was conducted. Because law school may want to play the smart one on you and just give you number of dates. Law school may tell you that the election was held on the 15th of maybe February, and the result was declared on the 17th. And they will tell you within how long does this man have to file the petition. Please start counting 21 days from that 17th, not from 15th. 15th was the day the election was held, but 17th was the day the result was declared. So you need to start counting from the day that the result was declared. And now that day that the result was declared will be excluded from the calculation. It will be excluded from the calculation. So you need to start counting from the next day. But assuming the next day is a Sunday or is a public holiday, then you need to start counting from the day after that public holiday or after that Sunday. So if it's Sunday, you need to start counting from Monday. And if it is a public holiday, you need to start counting the next day after the public holiday. So you don't count where it is a Sunday, you don't count where it is public holiday, and you don't also include the day that the result was declared. And it has to be within 21 days after that result has been declared, not 21 days after the election was held. Please, there are two different things, because most often than not, it is not always the day that the election was held that the results are declared. So you need to actually take that home. And there is no extension of time within which to file a petition. So once a petitioner fails to file his petition within 21 days, he is barred, he is statute barred, and he has lost his right to relief. However, it should be noted that the court or tribunal may extend the time within which to do any other thing under the Act, except the time for filing and the time for determination of that particular petition. An election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition. Please, not from the day of closing address by the parties, from the day of filing the petition. So the Election Petition Tribunal has 180 days from that day that the young man has filed his petition to determine that particular matter. So don't mistake it with saying that it is from the day that the parties have closed their pleading, or is it that the parties have closed their case? No, it is from the day that that petition was filed by the petitioner that the Election Petition Tribunal has to count is 180 days. So it is expected to deliver its judgment within this time. And the law is to the effect that when the judgment of the court or the tribunal is not delivered within 180 days, such a judgment will be invalid. Such a judgment will be invalid. That is the law, and there is no extension of time for this. So every judgment must be delivered within this particular duration of time. Now, for instance, now that the tribunal has delivered this judgment and you are aggrieved about the judgment and you want to appeal. Now, then an appeal from the decision of the election tribunal or court shall be heard and disposed of within 60 days from the date of delivery of judgment of the tribunal. So from the day that the tribunal delivers this judgment, then the appellate court that is hearing the appeal now has within 60 days to deliver his deliver his judgment on the appeal. So you now, who is the appellant, has within 21 days from the delivery of judgment to file your appeal. So you need to appreciate that. And in all final appeals, the court may adopt the practice of giving its decision and reserving the reason for the decision. I've said it before in our topic in judgment, and I'm repeating it now. For instance, now, if it is with respect to the court that has the final determination of a particular matter that relates to election petition, and there is no requirement or need of going to a higher court from there, then that particular court can say this is the winner, but without giving us the reason why this person is the winner. Because remember, we said that time is sacrosanct. So you are expected to make delivery of this particular judgment within 60 days when it is an appeal. So now you cannot, if you are the court of final appeal, you can pronounce the judgment and give the reason for it later. That is what we are saying now. It is in the case of AMPP versus Goni. Now remember, we have said that the issue of time, the 21 days you need to file, and the 180 days to determine the matter and all those stuff, it cannot be extended. So it is sacrosanct. We are still going to be looking at it once in a while as we go further in this discourse. Now let us look at the courts with jurisdiction in election petition. The courts with jurisdiction in election petition. The number one court with jurisdiction is the Court of Appeal. And Court of Appeal has jurisdiction in election petition over the office of the president and the vice president. So it is the Court of Appeal that entertains jurisdiction with respect to the election into the office of the president or vice president. And this jurisdiction is exclusive. It is exclusive. So they determine whether any person has been validly elected into the office of the president or vice president. They also determine whether the term of office of the president or vice president has ceased. They also determine whether the office has become vacant. And the composition of the Court of Appeal is at least 3 justices to determine this particular matter. And the quorum of that particular court is also 3 justices. So 3 justices have to sit on it, and the quorum must also be 3 justices. So quorum is the minimum number of persons that will be present before the matter will commence. And we now say that those 3 justices must also be present before the matter can actually commence. So where they are not present, then the court lacks the jurisdiction to entertain the matter. Now we have another type of court, or this one is tribunal. It is the National and State Houses of Assembly Election Petition Tribunal. And they are established in each state of the Federation and the FCT. So you know, if you check very well, you see that there is, in every state, there is an election into the National Assembly, the one we call federal constituency, and there is also an election into the State of Assembly from that particular state, which is from the various regions of the state. So this National and State House of Assembly Election Petition Tribunal is established in each state. It is established in each state, and their jurisdiction is to determine whether a person has been validly elected as a member of the National Assembly or State's House of Assembly. And this jurisdiction is exclusive. So there is no other tribunal that can entertain it if not them. It is exclusive. And the composition of this particular tribunal is that the chairman must be a high court judge, and it will now have 2 other members. And these 2 other members can be appointed from the judges of the high court. It can be cadis of Sharia Court of Appeal, can be judges of the customary Court of Appeal, or other members of the judiciary that is not below the rank of a chief magistrate. That is not below the rank of a, so this is the composition. So now remember that the chairman of this particular tribunal must be a high court judge. Now the tribunal is 3 persons. It is composed of 3 persons, and the chairman must be a high court judge and 2 other members who may either be high court judges or judges of customary Court of Appeal, or cadis of Sharia Court of Appeal, or any other person who is not below the rank of a chief magistrate. And the quorum of this particular tribunal is 2 persons, and it has to be the chairman and at least 1 member. Please, not 2 members, not 2 members. The chairman and at least 1 member. So the 2 members must not actually constitute the quorum. So the chairman must be present there and at least 1 member before they can hear the matter. And they are to be appointed by the president of the Court of Appeal in consultation with the chief judge of that particular state. They are to be appointed by the president of the Court of Appeal in conjunction with the chief judge, or sorry, in consultation with the chief judge of that particular state. And now we have the Governorship Election Petition Tribunal. We have the Governorship Election Petition Tribunal, and its jurisdiction is to determine whether any person has been validly elected to the office of a governor or deputy governor of a state. And the composition and quorum is the same as that of the National and State House of Assembly Election Petition Tribunal. So if you follow me very well in what I have said, in the National Assembly, House of Assembly Election Petition Tribunal, you will appreciate the composition and its quorum. So such is also applicable with respect to Governorship Election Petition Tribunal. Such is also applicable with respect to Governorship Election Petition Tribunal. Now, I want you to note the following. In the Federal Capital Territory, the Electoral Act prescribes the procedure for election into area council in Abuja. So meaning that election into the one we call local government in other states, Abuja call it area council. So now there is a provision for how election into these particular positions are actually conducted, and it is contained in the Electoral Act. But if it's for other states, election into the local government is controlled by the law of that state, not Electoral Act. You know that Electoral Act is a product of the National Assembly. So the National Assembly does not make laws for the states. So, and because now Abuja is not in itself having any governor, so it is the National Assembly that makes laws that guide Abuja, that is FCT. And any law that is made by the by the National Assembly is called an act. So Electoral Act now also regulates the election into the office of the area councils in FCT. And it establishes Area Council Election Tribunal for the FCT and the Area Council Election Appeal Tribunal for the FCT. Now, what you need to note now is that in this FCT, the Electoral Act provides for the Area Council Election Petition Tribunal. So, for instance, now, if you are not convinced about, if you're not okay about the conduct of an election in the FCT, that is into the Area Council, there is an Area Council Election Petition Tribunal where you're going to file your petition against the conduct of that election. And if maybe the Area Council Election Petition Tribunal gives its judgment, you are not also okay with it, then you can now go to the Area Council Election Appeal Tribunal, also in the FCT. And the decision of the Appeal Tribunal on Area Council election are final, so you don't appeal again. So once the Area Council Election Appeal Tribunal gives its judgment, it is final. It is final. Now, the Electoral Act does not create election tribunal for local government in the state, in other states. It is under the exclusive jurisdiction of the states. All right, let us look at parties in an election petition tribunal. Let us look at parties. We have 2 categories of persons who can present or file an election petition tribunal. The candidate in an election can present that, and the political party which participated in that election can also present a petition. And in election petitions, the parties are called petitioner and respondent. Petitioner is the person who is filing the petition, while the respondent is the person who is replying to that particular petition. And we say now that the petitioner can be the candidate that participated, or his political party. And the respondent can also be the candidate the candidate that was returned. So the respondent is always the person who won the election, because it's not thinkable that if you have been declared the winner, you'll be filing a petition. So most often than not, it's the person that lost the election that is the petitioner. So the respondent can be the candidate that participated in the election. His political party can also be joined as a respondent, and INEC can also be joined as a respondent in that particular matter. So we need to really appreciate that. Now, when a petitioner has filed his petition, remember we said that it has to be within 21 days from the date of the declaration of the result. He has within 21 days to file his election petition. So when he doesn't file the petition, he has lost his rights, because time is sacrosanct. Time is of the essence, and it cannot be extended. So when he has filed it, the respondent is expected to be communicated that this young man, that there is a petition against you. Then the respondent has within 14 days from the service of that petition on him to reply. And also this 14 days is also sacrosanct. It cannot be extended. So the respondent, anything he's doing should be within 14 days. Now, assuming the respondent has filed his reply and the petitioner notice that there are some new issues that have been raised by the respondent in his reply, the petitioner has within 5 days to file what is known as petitioner's reply. And remember, the petitioner's reply is in answer to the new issue raised only. It's only in answer to the new issues raised by the respondent only. So if you check very well now, you see that you have 21, 14, 5. 21 days to file the petition by the petitioner, 14 days to file a reply by the respondent, and 5 days to file another reply by the petitioner when new issues have actually arisen. And please, these times, these periods, these durations are sacrosanct. They cannot be extended. Time is of the essence with respect to election matters. Now, what are the documents that needs to accompany an election petition? You have list of witnesses, you have written statement on oath of witnesses, and you have copies of documents to be relied on. Now, another very important area we're going to be looking at is grounds for election petition. Grounds. So what are the grounds upon which somebody can actually file an election petition? Now, the grounds for election petition has been expressly provided for in Section 138 sub 1A to D of Electoral Act. Section 138 sub 1A to D of the Electoral Act. So anything you are doing, any ground that you are filing must be within the purview of this section. If you listen to my voice note on tips on how to draft on civil, I was explaining to us about how you will be required, or what will be required of you by Nigerian law school with respect to drafting election petition. They will just give you facts in a scenario. It is now your job now to know where each of these facts, the ground that each of these facts would actually fall in, because every ground you must have a fact that is supporting that ground. And those facts are the ones that will be provided for you by law school. Now, the grounds are the ones that you need to now use your head and appreciate. And I'm not saying now that we are not going to outline the grounds upon which a person can file an election petition. Then when you know the ground now, from the facts in the scenario now, you now know the grounds you are saying that this fact is now falling under it. Just listen to my voice note on tips of drafting in election petition, in a civil litigation. You are going to come across the election petition. I really explained it very well there. Now, the grounds, remember we said that they are contained in Section 138 sub 1A to D. So there is nothing that you are going to say outside any of these grounds. So you must either pick 1, 2, or 3 of the grounds. So you cannot go outside this ground to raise your ground. No, once you do that, then that particular petition will be irregular. All right, one of the grounds is that you can be arguing that a person whose election is questioned was at the time of the election not qualified to contest in that said election. That is one ground. It is contained in Section 138 sub 1A. The next ground can be that you can be basing your ground that the election was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act, and that non-compliance must be material to substantially affect the election. This is contained in Section 138 sub 1B. The next ground is that the respondent was not duly elected by majority of lawful votes cast at the election. This is contained in section 138 sub 1c. The next ground is also that the petitioner or his candidate was validly nominated but was unlawfully excluded from the election by INEC. Please, not excluded by his political party. If he's excluded by his political party, it is no longer an election matter. It is now a pre-election matter. But when it is INEC that excluded him, then it is going to be an election matter that can come before any of the tribunals. So we need to really appreciate that very, very well. Now, the hearing of an election petition is expected to be done in the open court, so where everybody can gain access to it. So there is nothing like secret private hearing of election petition. And on the day fixed for the hearing, if neither of the parties are present, then the tribunal shall strike out the petition, and no application can be brought again to release it again except on a good cause. Or if the petitioner is the one that is present and the respondent was not present, then he shall be asked to prove his case. If the burden of proof lies on him, and judgment will be given, and that judgment is final. Please, election petition is not a type that you require for default judgment. You cannot come and be telling the court, my lord, this young man is absent, give judgment in my favor. No. In election petition, you must prove your case. Even if the respondent is absent, you cannot be granted default judgment in election petition. So you must be required by the court for you to prove your case before the court may actually grant any of the reliefs that you are seeking. Now, where it is the respondent that is present, but the petitioner was not present on the day fixed for hearing, then he may be applying for the court to dismiss the petition. But where both parties are present, then hearing can commence. Then hearing shall commence. Now, generally, the standard of proof in election petition is on the balance of probability, generally. But however, where there is an allegation of crime or allegation of fraud that is contained in the petition, that particular allegation is expected to be proved beyond reasonable doubt. So whenever there is any allegation imputing crime against somebody, so that particular allegation is expected to be proved beyond reasonable doubt. Beyond reasonable doubt. Now note that in appropriate cases, the principle of the reasonable doubt, of proof beyond reasonable doubt, is only when there is an allegation of crime. So when there is no allegation of crime, then the standard of proof in election matters is on the balance of probability, or you can call it preponderance of evidence. Now, the filing of final written address shall be as follows. So when the parties have already closed their case, when the parties have already finished filing their replies and their petition, all those stuff, then they are expected now, after the hearing of the matter, to now file their written address. And the procedure for filing written address is as follows. When the party beginning, we used it before when we were discussing about closing address. Remember I told you it must not necessarily be the claimant that will begin. It's not necessarily the defendant. So anybody can begin the matter, anybody can commence. So even in election petition too, either the petitioner or the respondent can be the one commencing or the one that is opening his case first. So now the following are the procedure for filing final written address. When the party beginning has concluded its evidence, and if the other party does not intend to call evidence, then the party beginning shall within 10 days file his final written address. So 10 days from the close of evidence, 10 days from the close of hearing, that is close of evidence. So he has 10 days from then to file his written address. Now, upon being served with the written address, the other party shall file his own written address within 7 days. But where the other party calls evidence, so meaning if the party beginning called evidence and the other party also called evidence, then it shall be the other party now that will file his written address first. And he has within 10 days to do that, 10 days from the close of evidence. Now, upon being served with that particular close of evidence, then the party who commenced the matter first shall now file his own written address within 7 days. Now, the other party who files the address first shall now have a right of reply on points of law, and that reply shall be filed within 7 days. So if you follow very well now, you now notice that the number of days for filing of written address is 1075. So if the first person who is to file his written address has 10 days from the close of evidence to do that, while the other person who is to file written address has 7 days from when he has been served with the final address of the other party, and if that first person that filed written address has anything to address on points of law, maybe new issues that arose from the final address of the second person that filed, then he would have 5 days within which to file that. All right, let us look at judgment. How is the judgment of the court delivered? The following orders can be made by the tribunal in election petition. The following orders can be made. 1. Where the tribunal finds that the returned candidate was not validly elected on any ground, then the tribunal shall nullify the election. When the tribunal finds that the returned candidate was not validly elected on any ground, then the election shall be nullified. 2. Where the tribunal finds that the person returned had the majority of votes cast, but he was not qualified to contest at the election, then the court shall make an order for a fresh election to be conducted. 3. Where the court finds that the returned candidate did not secure the majority of valid votes cast, it shall declare as elected the candidate who scored the highest votes cast at the election and has satisfied the requirements of the Constitution or Electoral Act. For most of you that actually followed the Imo State election matter, this was the type of order that the Supreme Court made. 4. If the person returned as winner was validly elected or was validly returned, then the court shall dismiss the petition. Now, the court may uphold the petition and order that the person returned was not validly returned on the ground of lack of qualification and order for a fresh election. So it must be noted that judgment of the court must be entered within 180 days. 180 days from when? From the filing of the petition. 180 days from when? From the date that the petition was filed. It is very, very important. It's very, very important because we have already said that election petitions are sui generis. All right, let us look at appeals. So what if the tribunal finally gives the judgment now and you are not comfortable or happy and you want to appeal against the judgment? Can you? The answer is yes. So an appeal from the decision of the tribunal is to be filed within 21 days from the dates that the court or the tribunal gave that decision. So you have within 21 days, if you are aggrieved with the decision of the tribunal, to file your appeal. Now, the appeal is to be heard and disposed of within 60 days from the date of delivery of the judgment. There is no room for extension of time. And I want you to note the following. Any appeal that is from the National and State Houses of Assembly Election Petition Tribunal shall go to the Court of Appeal. Any appeal that is from the National and State House of Assembly Election Petition Tribunal shall go to the Court of Appeal. And any decision of Court of Appeal with respect to that is final. Any decision of Court of Appeal with respect to that is so, meaning there is no further appeal to the Supreme Court once the matter borders on election into the National or State Houses of Assembly. Now, it shall be noted also that appeals that are from the decision of the Governorship Election Petition Tribunal goes to the Court of Appeal. And if you are still not agree, so if you're still not comfortable or okay with the decision of that Court of Appeal, you can still further file another appeal to the Supreme Court. So if you notice now, when it is with respect to the Governorship Election Petition, then there are two steps of appeal. First appeal is to the Court of Appeal, and second appeal is to the Supreme Court. Now, decisions from the appeal courts, court of appeal, decisions from court of appeal with respect to determining whether a person was validly elected into the office of the president or vice president, such shall go to the court of appeal. And such shall go to the Supreme Court. I know that Supreme Court is the final arbiter typically, so there is no other court that you can go to when the Supreme Court has determined its matter. So from what we discussed now, you now notice that it is only the governorship election that there are 2 steps of appeal. You notice that it's only in the governorship election that there are 2 steps of appeal. Now, when you have filed your notice of appeal, you need to file it at that particular tribunal that gave the judgment. When you file it there, the registrar of that tribunal has within 10 days to compile records of appeal and send to the appellate court. Has within 10 days. Now, when the registrar fails to compile the records of appeal, the appellant has within 5 days to compile that. If you go to when we discuss on the topic of appeals, you will hear we use the word 60 days there and 30 days there. 60 days the registrar has to compile the records of appeal. Then if he fails to do so, then the appellant has 30 days to do that. But in election matter, which I have told you, it has a life and procedure of its own. It is 10 days for the registrar to compile, not 60 days. It is 10 days for the registrar to compile the record of appeal. Then when he fails to do that, then the appellant has within 5 days to so do. Now, when such has been compiled and the appellant has been served with the records of appeal, then the appellant has within 10 days to file what is known as his appellant brief. Appellant brief is when he will now canvass an argument that is in support of the grounds that he has raised, being the basis for his appeal. Now, when he has filed his appellant brief, the respondent will be served with that appellant brief, and the respondent has within 5 days from the service of the appellant brief to file what is known as his respondent's brief. And if there are new issues that has been raised by the respondent in his brief, then the appellant has 3 days from the reception of the appellant brief to file his reply brief. So if you listen very well now, you now see that what you have there is 10, 5, 3. 10 days to file appellant brief, 5 days to file respondent brief, and 3 days to file reply brief. All right, that is the much we're going to take in this particular topic, election petition. And until I meet you again, do take good care of yourself. But remember, go to my voice note on tips of drafting in civil. You will get the parts or the contents of an election petition, because most often than not, when there is a question on election petition, law school tend to ask you to draft the document that will be filed by the party. And remember, I normally tell you that law school may not open mouth and tell you draft election petition. No, they will just tell you draft the process or draft the document that is to be filed by the aggrieved party. So it's now your job now to know that the document they are requiring from you there is an election petition. Until I meet you again, take good care of yourselves and have a very peaceful night rest.